Well, good morning, everyone. You made it through the monsoons and got here, and we're just delighted to have you all join us this morning. My name is Nan Aaron, and I'm president of Alliance for Justice, which is an association of over 100 civil rights, public interest legal associations. And we are committed, among other things, to strengthening access to justice and the federal judiciary. And welcome to this forum, which we are calling Equal Justice for All, Are Pro-Corporate Decisions Hurting Everyday Americans? It doesn't take more than a glance at today's headlines to see that there's a battle being fought between everyday Americans and powerful corporate interests for control of our democratic institutions, our economy, and our courts. In fact, corporate bias is especially on display at all levels of our federal judiciary. We at Alliance for Justice are committed to shining a light on the consequences of this phenomenon on the courts in order to protect our rights and freedoms. With our numerous reports on corporate influence on the courts, our organizing efforts, we are working hard to ensure that all voices are heard in our courtrooms across America, not just those of wealthy and powerful. And many of you know how involved Alliance for Justice is and how much we are in the forefront of efforts to get the White House and work with our friends in the Senate to step up the pace of confirming federal judges. I know Senator Whitehouse agrees that we need to end the tactics of obstruction that have left President Obama with the worst record on confirmations of any president in history. But thanks to the hard work of Senator Whitehouse, some progress has been made. Today we have a great panel lined up. And to get us started, we're honored to be joined by Senator Sheldon Whitehouse, who has emerged as one of the most thoughtful, respected, and effective members of the United States Senate. His background is extremely impressive. He went to Yale and then to the University of Virginia School of Law. He was the Attorney General of Rhode Island and a U.S. Attorney and was elected to the United States Senate in 2006. We know him best, of course, for his extraordinary work on the Senate Judiciary Committee. Those are truly stellar credentials, but what really impresses us about him is his depth of knowledge, his willingness to stand up for the rights of everyday Americans, and his intuitive grasp of what's at stake in today's highly charged political environment. He's been one of the most important additions to the Senate in many years, and we're extremely proud to work with him to strengthen the courts and protect the rights of Americans. His interest in the subject of corporate influence in the courts was on display during the confirmation hearings for Elena Kagan, and we're eager to hear more this morning. I'm honored to present one of the Senate's great stars, Sheldon Whitehouse.
Well, thank you, Nan, for that exaggeratedly kind introduction. And thanks to all of you for the great opportunity that this presents to speak with all of you on our nation's promise of equal justice for all. The work that the Alliance for Justice does in this area is extremely important, and it helps people like me feel that we are not lonely voices. So thank you very much for organizing around these principles and putting this effort in. And I know that some of your members are seeking to contribute in other ways as well. Byron Georgia was just filed for the Democratic Senate seat in Nevada, and it would be exciting to get that seat, now occupied by Senator Ensign, into Democratic hands. America's signal achievement at its founding was the balanced, divided system of government that remains in place today. Within that beautifully designed mechanism, our nation's founders created one institution of government in particular, the jury, to assure that everyday Americans retain a forum where they can get a fair shake against powerful interests. Appearing before a jury, of course, does not guarantee that a case will have a certain outcome, does not guarantee that an American worker can keep her job, that citizens can safeguard their community from outside pollution, or that parents can protect their child from injury. But the jury has always been the last best redress for injuries to everyday Americans. The founders put the jury in 3 separate provisions of the Constitution and the Bill of Rights. They did so for a reason. They understood that, as William Blackstone had explained, and I quote, "The most powerful individual in the state will be cautious of committing any flagrant invasion of another's right when he knows that the fact of his oppression must be examined and decided by 12 indifferent men and women nowadays." The long sweep of American history confirms the jury's role as a core institution in our system of self-government. In his remarkable book on our country, de Tocqueville observed, "The jury is before everything else a political institution. One ought to consider it as a mode of the sovereignty of the people." De Tocqueville says this, by the way, and discusses the jury in the chapter entitled "On What Tempers the Tyranny of the Majority." The jury serves as our last sanctuary as Americans when the forces of society may be arrayed against us, when the governor's mansion has been bought by special interests, when lobbyists have the legislature tied in knots, when the newspaper owners have steered public opinion against you. The hard square corners of the jury box stand inviolate against the influence and money of special interests. The jury is particularly important today as powerful corporations encroach ever further into our political system. In the Supreme Court's Citizens United case, a slim 5-4 majority allowed giant corporations unlimited license to drown out the voices of American citizens in our elections. To give you a sense of the scale of this threat to everyday Americans' role in our democracy, presidential candidates Obama and McCain together spent a combined total of slightly more than $1 billion on their campaigns. In contrast, one corporation, ExxonMobil, had sales of $89.8 billion and profits of $19.4 billion in the year that Citizens United was decided. Corporate giants now have the ability to influence our electoral system like never before. With 5% of 1 year's profits, one corporation could match the entire combined presidential campaigns of both Senator McCain and then Senator Obama. Big corporations can now dominate the executive and legislative branches through campaign spending and lobbying. But there's one annoying little place where their money and influence can't reach: the jury box. Indeed, tampering with a jury is a crime. Wealthy and powerful interests take little joy in the jury's role safeguarding the sovereignty of the people, and don't much like the notion that oppressions, even by the most powerful, can be examined and decided by 12 indifferent men and women. So it is not for nothing that in recent decades, corporate interests have embarked on a sustained effort to weaken the civil justice system and diminish the role of the jury. From a historical perspective, there is no question whether corporations or the jury has a richer constitutional pedigree. The founders did not consider corporations to be citizens of our democracy. Corporations are not mentioned once in the Constitution. Indeed, private business corporations were rare at our nation's founding. Between 1781 and 1790, all of our states combined issued just 33 charters to public business corporations. That was the form then. Yet, for all certain members' purported originalism, in case after case, the Supreme Court has given big corporations repeated victories, restricting the jury's constitutional role as protector of everyday people. These cases have brought harsh consequences to American workers, consumers, families, small businesses, and communities. We all know the case of Lilly Ledbetter, for instance. After learning that she'd been paid less than her male counterparts year after year, despite working just as hard, Ms. Ledbetter brought suit against her employer. A jury heard the evidence in the case, found that the big corporation had indeed discriminated against Ms. Ledbetter and awarded her back pay and damages. Then the corporation got the case before the Supreme Court. The conservatives on the court decided to take the decision away from the jury. In so doing, these justices failed to heed the practical realities of the workplace, of the working women who were paid less for equal work but didn't know it, and concluded that an employer could keep an employee from challenging wage discrimination before a jury so long as it successfully hid the unfair treatment from the employee. In Gross v. FBL Services, a 50-year-old man claimed that his employer had discriminated against him because of his age. A jury agreed. Again, the corporation turned to the Supreme Court. And again, a narrow majority of justices overturned the jury decision, in the process making it more difficult for older Americans to prove they were wrongfully discriminated against on the basis of age. In other cases, the court has diverted working Americans away from a jury by forcing them before an arbitrator. In Rent-A-Center, for example, the court stopped American employees who work under binding mandatory arbitration agreements from challenging unfair treatment by their employers in the court. Americans, this same slim majority held, cannot even go before a court to challenge whether the arbitration agreement is unconscionable. It is the arbitrator who decides whether the arbitration agreement is unconscionable. In environmental cases, too, the court has insulated corporate interests from the jury of everyday Americans. In Exxon v. Baker, for instance, the court decimated the jury's punitive damages award against Exxon, giving Exxon a mighty windfall to the detriment of the seaside communities who today are still damaged by the consequences of that Exxon Valdez oil spill, and undermining the ability of the law to deter and therefore prevent future oil spill disasters. Even in cases between businesses, the court has trampled over jury decisions to the detriment of American consumers. Consider the Legion antitrust case, where the 5-4 majority on the court reversed many decades of precedent that had kept prices low for consumers and had helped small businesses compete with corporate giants. In that case, too, the conservative bloc overturned a verdict from a jury of everyday Americans. And then there are the decisions in Twombly and Iqbal. In these cases, as you know, the Supreme Court overhauled the long-settled standard for what an injured person must allege in a complaint to get a case to a jury. After Twombly and Iqbal, American workers made sick on the job, families who've had a child injured by a defective product, or older Americans who've had their retirement savings wiped out because of securities fraud, all will have a harder time holding corporate wrongdoers accountable before a jury. All of these cases have common characteristics. they short-circuited the jury process, either overturning the considered decision of a jury or changing the law so that Americans cannot present their case to a jury. And they preferred corporate interests to the rights of everyday Americans. Big corporations long had sought these victories, having waged a relentless campaign against our civil justice system. Their victories will not be widely shared, however. This is not a case in which what is good for the big corporations is good for America. Instead, these decisions will undermine corporations' incentives to treat workers well, to create safe products, and to properly inform investors about their finances. For all the proclamations by my Republican colleagues about Supreme Court justices just calling balls and strikes, it seems undeniable that big corporations' success has resulted in part from efforts to fill the courts with activist judges sympathetic to corporate interests and views. Activist judges, did I say? That may be a little surprising. We've heard for years complaints of liberal judicial activism. Well, I recently wrote an article that offered 5 objective measures or red flags that might allow us to recognize real judicial activism whenever it occurs from whatever side. First, an activist court would be less likely to respect the judgments of the American people as expressed through state and federal legislation, since they would have an agenda of their own. Second, an activist court would chafe at unwelcome prior precedents because they would conflict with the agenda of their own. Third, an activist court facing the choice between securing a broad consensus on the court and allowing a bare majority to carry the day would go down the path that allowed it to reach farther in the ideologically satisfactory direction of accomplishing its agenda, even though by bare majority. Fourth, an activist court would be more likely to ignore longstanding practices of appellate decision to reach a particular desired outcome. And fifth, an activist court, whether conservative or liberal, would issue decisions consistent with its ideological preferences, and over time, a discernible pattern of results would likely emerge. The current conservative majority on the Supreme Court is flying each and every one of those flags. It fails to respect the legislative process provided for by our Constitution. It shows little respect for precedent, repeatedly issuing 5-4 decisions that dramatically alter the legal landscape. It has selectively ignored the rules of restraint that govern appellate decision-making. And as we have seen, clearly discernible patterns have emerged from the decisions imposed by the conservative bloc of the Supreme Court. Corporations, in particular, have prevailed at striking rates on issue after issue, leaving everyday Americans out in the cold. This activist trend gives reason to worry that the trajectory favoring corporations over everyday Americans will continue. A lot is at stake in cases before the court this term. In AT&T Mobility, corporations have asked the court to take away consumers' rights to participate in class action arbitrations. In American Electric Power, corporations have sought to curtail citizens' rights to go to court to challenge the nuisance created by polluters emitting greenhouse gases that cause climate change. And in the Walmart case, a corporate giant has asked the Supreme Court to block, to block women from joining together to challenge before a jury discrimination in pay and promotion. Pro-corporate decisions in these cases could do great damage to consumers, to the middle class, to the environment, and to established law. It does not have to be this way. Courts have been a beacon of liberty and justice in America, and they can readily play this role again. I grew up in an era in which federal courts were truly the sanctuary for those who the rest of society had turned against, particularly in the South. Judges at all levels of the judicial hierarchy can ensure that the court system protects the rights of everyday Americans. Many on the bench take that responsibility seriously. In one recent local example, federal bankruptcy judges in Rhode Island and in New York have instituted programs in their courts in foreclosure cases so that the people at risk of losing their homes actually have the chance to talk to a human being from the bank before they are ejected from their homes. While one big bank is fighting that requirement tooth and nail, these programs make clear that our judicial system can continue to offer a forum for all people, everyday people, not just special interests, not just corporations. We too have a role to play. Those of us who see the harsh consequences of pro-corporate decisions must fight harder for equal justice. We must stand up for the institution of the jury, a body that truly is of, by, and for the people, and that has as good a constitutional pedigree as any element of our system of government. As advocates, we must think smarter and work harder to make sure that judges respect the constitutional rights of all Americans. And as citizens, we must engage in the political process, shine light on the harm done by activist judges at the expense of the American people, expose the campaign to populate the American judiciary with more of them, and work to confirm judges who will live up to the ideal of equal justice under law. Let me close by repeating the words that I quoted at the outset from de Tocqueville and Blackstone. The jury is, before everything, a political institution. One ought to consider it as a mode of the sovereignty of the people. The most powerful individual in the state will be cautious of committing any flagrant invasion of another's right when he knows that the fact of his oppression must be examined and decided by 12 indifferent men. These words echo to us across the centuries and should give us faith in our cause. I thank you for joining me in this effort, and I thank you again for the opportunity to be with you here today.
Thank you. I'm wondering if there are any, that was wonderful. Thank you. Wondering if there's some questions for the senator before he has to
Questions,
leave.
comments, rude remarks?
Yeah.
We take them all.
Sally.
Hello, Senator. Thank you so much for those remarks. You mentioned the Concepcion case, AT&T, the class action case, which is, I'm a consumer person, consumer advocate, and that's a huge case with huge implications, obviously, if we lose it. What chance do you think there would be if we needed to come back to Congress to address the problem of rectifying the Supreme Court's decision, should it turn out to be go against consumers and go against those of us who believe that people should have a right to bring class actions?
I think it would be very challenging in this Congress, as presently constituted. Let me give you an example. I fought for a bill that would protect Americans when imported products injure them. Very often an imported product comes into this country, and when it injures a consumer, you can't find the manufacturer to hold them responsible. And if you can find the manufacturer, the only way you have access to them is through complex international treaty provisions, and then you have to abide by the law of the foreign country in terms of having the complaint stamped by different ministries and translated into their language, and by the time you're done, weeks and months go by. We had testimony that people were spending $20,000 to $30,000 just to serve process. Every American corporation, when it does business in another state, has to file an agent for service of process in that state. It's sort of uncontroversial background automatic plumbing that keeps our system running efficiently. So I thought, well, if you're going to be importing stuff into our country, this was particularly in the wake of the Chinese wallboard and the destruction that the Chinese wallboard has done to houses from the sulfur that it emitted and that degraded the copper and caused people to have to leave and caused injuries and all of that. So it was a very simple piece of legislation that would have required anybody importing a product to have to file an agent for service of process somewhere in the United States so that you can have access to them. Good, you would think, for American business, because if you're the contractor from Alabama who I called into my hearing, who had to make good on the damage that his customers sustained from the crummy Chinese wallboard, you're now carrying the freight for the Chinese derelict company. But because these were his customers and it was his reputation, he had to make good on it. So the liability fell to him, even though the fault was elsewhere and there was nothing to be done about it. And it's true, it's an uneven playing field for American manufacturers against foreign manufacturers if they can insulate themselves from liability. You would think that would be a slam dunk. It was not. Indeed, the US Chamber of Commerce came out against it. I doubt many of their small and local members knew that, but obviously the US Chamber of Commerce is much more attuned to the interests of the international corporations than it is to American corporations, and they carried the day on that, and as soon as it was clear that the US Chamber of Commerce was against it, Republican support, which had been very interested, evaporated like a shallow puddle in the hot sun.
Is there an opportunity now to move more judges through the Senate, or is that just wishful thinking?
There's an opportunity now to move more judges through the Senate. There will come a time when it gets close enough to the presidential election that there will be a general shutdown on all judges, and we don't know when that's going to take place. Ordinarily, it's in the spring, late spring of the election year, but there's no reason that the Republicans couldn't declare it to be Christmas or Thanksgiving. And so, you know, it's important that we press forward. We also have more floor time in the Senate now because the minority in the Senate no longer needs to use its procedural mechanisms to obstruct and delay everything. They have a House of Representatives that can stop anything dead that they don't like, so they don't need to be as obstructive. And because we are not in a position to accomplish much legislatively, given where the House is, we have, again, more time, and it's important that we do so. The mechanism that is taking place out there right now is that the great pools of non-controversial judges are coming through the Judiciary Committee and going onto the executive calendar on the floor and then sitting there. And it's really hard to call them up. They're blocked on the Senate floor. And they're blocked on the Senate floor so that they can create a hostage pool so that the minority can say to the majority leader, we have these controversial judges we don't want to have to vote on. And if you make us vote on them, we're going to hold the hostage pool. And if you promise not to bring them up, we'll let big chunks of judges go through, 15, 20 at a time. The only way you break that mechanism is by forcing votes on the so-called controversial judges, some of whom emerged from committee with bipartisan votes. So, you know, you can wonder how controversial they really are, but you can usually look behind the screen and find that there's a special interest that thinks they're controversial. So it's really important to press on that. And it's important for all of us to watch this because never in the history of the Senate has a United States District Court nominee failed to achieve confirmation as the result of a filibuster. Only 3 times has cloture been invoked on district judges in the 70 years that the cloture rule has been there, and it didn't block a one of them. It looks as if each of those were warning signals to somebody on another matter to pay attention and get that resolved, and then the judge would go. So if the Republicans are going to start a process that for the first time allows for the filibuster of district judges, supported by both home state senators, cleared the committee, supported by the American Bar Association, background check complete. If that's going to be the new standard, they're letting out a very big tiger from a cage, and it is never going to go back in again. So they don't want to do that, but they don't want the judges either, and the hostage theory is the way you work around that problem, and the way you solve that, I think, is to call the bluff, force the vote, see if they filibuster. If they do, okay, we're in new territory, we'll understand it, we'll remember it. And if not, we get these judges cleared, and then there's no value to holding the non-controversial ones hostage any longer, and with any luck, that will begin to accelerate the process. Bill.
I'd like to know what we can do about it. Step up to the mic, please. Sure. I find it surprising that, frankly, any of the current nominees are controversial at all. They come primarily from backgrounds as prosecutors and corporate lawyers. And there are very, very few whose life's work has been the representation of natural persons confronted with the problems of everyday life and real-world experience. And those are the people we need on the bench. And our Democrats are not putting those names up. And I'd like people with that kind of background up in any kind of sufficient quantities to have any kind of chance of evening the playing field between the middle class and the poor and corporate America. And I'd like to know what we can do about it.
These are decisions that usually get made, particularly at the district court level, by the home state senators. It is on the home state senator's recommendation that the president makes his nomination. And so there's no particular person to yell at about this other than, you know, in state by state and appointment by appointment to push the senators. Into every senator's calculation goes an issue of confirmability. And that, I think, is why it's important to push back on this sort of faux controversial standard, because what it allows the Republicans to do is to march the 50-yard line more and more towards their goal line by simply declaring people to be controversial, by holding them up, by being difficult, by being obstructive, and then that influences the judgment of people about who is confirmable, and it becomes kind of a self-perpetuating and self-fulfilling cycle, which makes it all the more important from a process point of view and from a systems point of view that if somebody is qualified, has cleared their FBI background check, has the recommendation of the ABA, and has the support of their two home state senators, and in the case of at least one of the so-called controversial judges, cleared the Judiciary Committee with a bipartisan vote, we ought to be just forcing that issue and pushing back on this question of controversialness, because otherwise they will just inch us and inch us and inch us until their goal line and the 50-yard line are indistinguishable.
We have one last question.
One last question.
Sarah. Sarah?
Well, two then, if there are two people waiting.
All right.
Hi, I'm Sarah Doofendock. I work for Common Cause. I think one of the reasons that the judiciary seems to be so pro-business might be that, shockingly, the Supreme Court doesn't fall under the Code of Ethics, the Judicial Code of Ethics. They can take like unlimited gifts. They can travel on the corporate dime. They can go, all around the country. And I'm just wondering, I think that, the Citizens United case is a case that I think is just devastating in terms of what corporations can do to further encroach on the citizens' rights and basically by the legislature. And I'm just interested in the thoughts that you might have about how do we fight Citizens United? How do we cope with it? It just seems to us that this is just so incredibly devastating. And then one other thing is, do you think that there's any chance that the Senate might do hearings on, the Supreme Court being brought in under the Judicial Code of Ethics?
I think it's possible. I certainly wouldn't rule it out. I don't think it's on the judiciary agenda at the moment. I think there is real cause for concern as these incidents mount one after another, and the cumulative weight of them begins to suggest that particularly the four conservative justices, the patterns begin to develop. And at some point, a pattern becomes so distinct that it requires attention. It's certainly distinct enough that it's beginning to look like a bit of a pattern. It may take, a few more incidents before it rises to the level of judiciary attention, but I'm delighted that Common Cause is looking at this. I think it's a really important issue. On Citizens United, all that we can do is to require disclosure. And I think this is a very good issue that we need to be persistent on. And I would urge all of you to urge everybody who you talk to in Congress, particularly in the Senate, to be persistent on this. It's not enough to call it up for a vote, have the vote, and say, okay, we tried, and walk away. This is one of those issues where you have to go after it again and again and again and again and again, because we're right on this. The public is with us. I think the decision was legally defective, but it's going to be a long time before a court emerges that will turn it around, I think. But we can at least accomplish what the court left us the ability to do, which is to require transparency in all of this. And I think it's a tough vote for the Republicans because they're advantaged by Citizens United so much that they don't want to have big corporations have to disclose who they are when they run ads. And but Joshua didn't get the walls down around Jericho on his first trip around either. It took 7, as I recall. And this is one of those things where you just have to pound at it and pound at it and pound at it and pound at it and make it defining. Because people really are worried in this country about the extent of big corporate control over our government. And Citizens United is a scary decision, not just because of what will go up on the air, but because of what won't, and because of what conversations will lead to what won't. The thing that worries me the most about Citizens United isn't the smear ad with millions of dollars behind it by Citizens for Peace, Love, and the American Way, and nobody knows who they really are. That's bad enough. The thing that really worries me is the meeting in the senator's office between the lobbyist and the senator saying, boom, here's your 30-second spot. Take a look. We're putting $5 million behind this spot unless you vote our way on this. That nobody even sees. That is just the silent cudgel under the table, and that is the greatest danger to democracy from Citizens United.
Human rights litigation, which is a community that's still reeling, I think, from the Kiobel decision last fall in the Second Circuit saying that corporations can't be held accountable for their human rights violations. And given the split with the 11th Circuit, I foresee that eventually making its way to the Supreme Court. But as you've mentioned, given the current composition of the court and given the current composition of Congress, it doesn't seem like it's an ideal time to be opening up the Alien Tort Statute for any amendments. And I'm wondering if you have thoughts on alternative solutions or what the future looks like in the human rights area for corporations.
I really couldn't say. I'm sorry. This is not a great legislative environment for any of that. It is not a great Supreme Court environment for any of that. I think in some respects we have to do our best to sort of keep the flame alive during this period for when things turn, as they tend to in democracies. And also, I think, do our best to ground our arguments, as I tried to do today, in really basic constitutional principles. The folks who came into Washington recently with the intense backing of the Tea Party came in with a very strong sense of allegiance to the United States Constitution. I don't think a lot of them have really focused on the fact that the jury, for instance, is a well-established part of our American system of government, established by the Constitution and Bill of Rights, in there for a reason, with impressive pedigree from people like de Tocqueville and Blackstone and the Founding Fathers behind it. And I think the more we ground our arguments in those areas, the stronger we will be. If we're just talking about rights, I think it's a harder case. You've got to go to ground your arguments in the areas where your opponents feel comfortable. Thank you very much.